I was asked to give this address rather late in the day, and of course it's a great honour for me, so I say thank you to the organisers. And I can only assume it's because I have been in-house and also in private practice, and I've done the sort of revolving door. So having been in private practice, I went in-house and have now returned to private practice. May I, just to know who my audience is and that I'm not preaching to the converted, may I ask for a show of hands of those who are currently in-house? And then those who were, the currently in-house, keep your hands up. And those who have been in-house at some point in their career. Any additional hands? Right, a couple. So a couple of other people have also done both. Right, thank you very much. Now, if I start to shake, as I was introduced, and I came in to London, the aircraft was hit by lightning. A first for me, and we had to land at Stansted rather than make it to Heathrow. So forgive me, I'm going to stay seated, and I will put down any nervousness. Please forgive me and think it's the lightning that's creating the wobbly hand. Right. The topic of this conference is the risks and rewards of litigation in the international environment. My particular specialisation has been dispute resolution in its broader sense, so I do not see myself as a litigation practitioner, but I see myself as someone who knows what the tools in the toolbox are in order to resolve a dispute. And I think the risks and rewards means if you are going to manage litigation or whatever your dispute requires, you really need to familiarise yourself with all the options available. And in-house lawyers, as well as private practitioners, must develop an approach that means that at the time the transaction is happening, dispute resolution lawyers are involved in order that, should you have to go to litigation, should you have to dispute a claim, should you have to defend yourself in a dispute, you're in the right forum. So I cannot stress that enough, because my point later on will be that jurisdiction is a huge stumbling block and creates one of the largest risks of your dispute going off the rails. So, first plea is, in-house lawyers, be aware that you need to be there with your transaction M&A people, your IP people, when anything is happening in the early stages. That is a way of avoiding risk. Once you turn to outside lawyers, I would say use people who are so familiar with your particular area of business, who have a broader expertise, so that they have a substantive knowledge of your industry and know what sort of problems could arise. Again, get them involved in different departments, so that you have the dispute resolution lawyer there advising you on your forum for settlement of a dispute. Litigation in the United States is not usually recommended, and equally there are problems with other jurisdictions around the world. And I think that is why, undoubtedly, international arbitration achieved the popularity that it has in only 20-25 years, because getting the forum right was really quite a tricky one and opened you up as a corporate client to tremendous risks if you were in the wrong jurisdiction. The other risk that I will allude to now briefly is that the outside law firm that you turn to must also not have its own vested interest, and that the people you're dealing with are people who you trust and who will be there to offer you the best service, i.e., they will understand that from an in-house perspective, settlement of this dispute is what we want. And the sooner we can get settlement, the better. We don't necessarily want a long, protracted dispute, and I fear that that is what can sometimes happen. And you go from appeal to appeal to appeal, and then back all over again when it's referred to first instance. And that is not what a corporate client really wants, unless there is another motive. And that, of course, is something that you would need to discuss with your outside lawyers, who you hopefully trust to do the best for you. And so choosing the outside lawyer is a very important step for in-house counsel. And I think outside practitioners must understand this burden that they carry and really give the best advice they in any situation that they can possibly do, and try to really see it from the client's perspective, so that windows of opportunity for settlement are always there, where you're looking as outside counsel as well as in-house counsel to avoid going too far into conflict and the risk of never ever then being able to settle in a fashion that could possibly have been there at some point. So these are the two main areas of risk that I consider to be paramount from a lawyer's perspective, what to avoid. Jurisdiction, I'll come back to briefly, is where do you bring your claim? And the need to identify the forum. It could be the courts of a national entity, of a country that you trust. And you need to sort of look at the attitudes in the courts if you're in an international transactional cross-border project. I come from Austria, which I have chosen as my Vienna is my home practice because I married an Austrian. I'm actually an English solicitor, but I married an Austrian diplomat. And in Austria, Austrian firms try to get their local courts to handle any dispute they have with their foreign partner, because they're very comfortable with the way the courts manage things. If not, international arbitration is chosen. Central and Eastern Europe used to be a little bit of cowboy country in the days of 20 years ago. In the meantime, these different nations have established the rule of law, and you can feel quite comfortable in the courts of a neighbouring country to Austria without any cause for desire to change that, should it be what the parties then feel comfortable with. Russia, where I have also practiced, was not a jurisdiction that one felt comfortable with in the local courts, and hence the predominance of English law and the use of the English courts or international arbitration for resolution of those sort of disputes. What I have been following closely has been the UCOS case, and I'm sure you're all familiar with the changes that have happened just recently to what everyone thought was a phenomenal result. And that was all to do with jurisdiction. Now that perhaps is an unusual case to point to, but nevertheless, I really cannot stress, from my perspective, when I was in-house, the number of times we fought claims on jurisdiction and the number of times we were successful on jurisdiction really made me see how important choosing the jurisdiction is. And so your risk of being in the wrong jurisdiction is very high. Point 2, as I said, I'm going to just identify from my perspective 2 areas of risk, is having advisors who do not follow carefully when you could settle this claim and help you to reach settlement. There are sort of points in any dispute where you put pressure on a party to bring them to the negotiating table. And that is the strategy. You need good partners to help you see, we're going to use X, we're going to use a legal process in order to bring the opposing party to the negotiating table and use those windows of opportunity to then negotiate a settlement, which is to the advantage of both, so that you have a win-win situation. Because ultimately, a corporate client is looking to do business, and business continues. If you're an investor in a country, you want to continue investing in that country. You want things to work. You don't want things to be destroyed. You want relationships to be built. And so I really urge outside counsel in this room to think in terms of finding those windows of opportunity, advising your client in the sense of this is the right moment, the reward of settlement at an early stage. Risks and rewards means you win, you lose. I like to think that we're not in a one party loses situation. I like to take a more humane approach and try to say that we have win-win situations. And I don't really foster and encourage the going the whole hog and absolutely using a sledgehammer to crack the nut. There will be different situations, and I don't want to make a sort of overall generalization that has no relevance in the business community. But my message is the rewards of litigation are usually the reward of having brought the party to a sort of sensible, reasonable recognition that the time has come to negotiate properly and let's get it sorted. If you're the claimant, you may be feeling that you have a very unreasonable party on the other side. If you're acting for a defendant, you may feel you have a very unreasonable claimant where you've been trying to offer solutions for a difficult problem and the other side has simply not understood the problem. And it all comes down to good communication. The perils of bad management by a law firm which goes off on a folly and does something that it doesn't inform the client of, all comes down to communication as well. I would say when you're in-house, you sometimes question, why has my outside lawyer done this? And you hear after the event, never allow that to happen. Make sure that there is a good toing and froing, keeping the client informed, keeping the client aware of the consequences of an action. A could happen, B could happen, and then what is plan A and what is plan B, what are the options. Keep the lines of communication open at the level of the corporate entity, the client, with its outside lawyers, and then between the parties, so that the reward of settlement early, payment, whatever financial flow comes from it, comes sooner rather than later, and relationships are built and maintained. I believe those are the rewards. I'm going to quote something that in the time that I was sitting on the plane, not able to disembark, I was reading the business magazine of British Airways, and there is an article in there which I thought was quite useful for anybody, talking about relying on your gut instinct. I overheard someone saying, or rather going to say, our welcome address has repeated it, don't want to win the battle and lose the war. And I can only say that must be our real sort of modus operandi. We don't want to win a battle and lose the war. And the quote is, great advisors are the ones who give you the scaffolding to observe your gut instinct from every angle and arrive at decisions which allow you to flourish. Advice is best when it's of high quality, with provenance, and in small amounts following your developments. I think that is something that we could apply to ourselves as legal advisors in dispute resolution. Thank you, everyone.